Welcome! The Office of the Chief Data Officer and the Texas Department of Information Resources are proud to offer this course on data privacy. We hope you will find this a valuable resource as you continue your journey to becoming more data literate. This course consists of several sections focusing on data privacy. We will talk about privacy principles and look at some of the laws and regulations that impact the collection, management, sharing, and use of public sector data. By the end of this course, you'll be able to understand the privacy principles that governmental organizations should consider as they collect, process, maintain, and disclose personal information. Describe privacy laws and regulations that apply to governmental organizations. And describe laws related to unauthorized access to data and right to information. At the end of the course, there will be a quick knowledge check to make sure you've understood the main points of each section. Data privacy involves a person's ability to exercise control over how their personal information is collected and used. As the legal and regulatory environment surrounding data privacy is complex and continuously evolving, the requirements we will discuss are by no means exhaustive. However, they should impart a broad understanding of the legal requirements on data in the public sector. Note that any requirements discussed in this course are provided for informational purposes only, and are not meant to convey legal advice or otherwise direct you on a particular course of action for your data program. Please consult your organization's legal counsel if you have any questions about the laws and regulations presented here. Laws surrounding the government's collection, retention, and use of data can be traced to the overarching purpose of public sector data governance: to ensure the transparency and accountability of the government to the governed. Right to information laws at the federal, state, and local levels give citizens the right to data about the operation of their governments. Privacy laws ensure that personal data collected about citizens remains private except in very limited and well-defined circumstances. Texas law generally grants individuals the right to be informed about information that a state governmental organization collects about them. Under Chapter 559 of the Texas Government Code, state governmental organizations that collect personal information from individuals must post a privacy policy on their public website, which explains what personal information the organization collects, such as names, contact information, IP addresses, and so on. State governmental organizations collecting this information are also required to provide individuals with opportunities to review their personal information and correct any inaccuracies. Before we discuss any of the privacy laws and regulations that apply to Texas state agencies and institutions of higher education, we should first talk about the privacy principles that have influenced those laws and regulations. In 1973, the U.S. Department of Health, Education, and Welfare released a report focusing on the impact of computerization on information privacy. That report described Fair Information Practice Principles, commonly referred to as FIPS, which have since been adopted and adapted by organizations and governments across the globe as responsible data practices for those who collect or use personal information. While the FIPS themselves are aspirational, many aspects of them have been incorporated into state and federal privacy legislation. Let's talk about the Fair Information Practice Principles that are recognized today. Access and amendment. Agencies should provide individuals with appropriate access to their personally identifiable information, or PII, and the opportunity to correct or amend inaccurate PII. Accountability. Agencies should be accountable for complying with these principles and applicable privacy requirements, and should appropriately monitor, audit, and document compliance. Agencies should also clearly define the roles and responsibilities with respect to PII for all employees and contractors, and should provide appropriate training to all employees and contractors who have access to PII. Authority. Agencies should only create, collect, use, process, store, maintain, disseminate, or disclose PII if they have the authority to do so, and should identify this authority in the appropriate notice. Minimization. Agencies should only create, collect, use, process, store, maintain, disseminate, or disclose PII that is directly relevant and necessary to accomplish a legally authorized purpose, and should only maintain PII for as long as is necessary to accomplish the purpose. Quality and integrity. Agencies should create, collect, use, process, store, maintain, disseminate, or disclose PII with such accuracy, relevance, timeliness, and completeness as is reasonably necessary to ensure fairness to the individual. Individual participation. Agencies should involve the individual in the process of using PII, and to the extent practicable, seek individual consent for the creation, collection, use, processing, storage, maintenance, dissemination, or disclosure of PII. Agencies should also establish procedures to receive and address individuals' privacy-related complaints and inquiries. Purpose specification and use limitation. Agencies should provide notice of the specific purpose for which PII is collected and should only use, process, store, maintain, disseminate, or disclose PII for a purpose that is explained in the notice and is compatible with the purpose for which the PII was collected, or that is otherwise legally authorized. Security. Agencies should establish administrative, technical, and physical safeguards to protect PII in line with the risk and magnitude of the harm that would result from its unauthorized access, use, modification, loss, destruction, dissemination, or disclosure. And finally, transparency. Agencies should be transparent about information policies and practices with respect to PII, and should provide clear and accessible notice regarding creation, collection, use, processing, storage, maintenance, dissemination, and disclosure of PII. While these principles aren't law, the FIPS can help frame conversations about good privacy practices. See if you can recognize aspects of the Fair Information Practice Principles as we discuss some of the privacy laws impacting Texas state agencies and institutions of higher education as they create, manage, share, and use data. One federal law with implications for Texas is the Family Educational Rights and Privacy Act, or FERPA. FERPA protects the privacy of student education records and applies to all schools and institutions that receive funds under a program administered by the U.S. Department of Education. FERPA gives parents certain rights with respect to their children's education records, and these rights transfer to the student when he or she reaches the age of 18 or attends a school beyond the high school level. Rights covered under FERPA include the right to access the child's education records and an opportunity to seek to have the records corrected if they are believed to be inaccurate or misleading. Generally, schools and institutions must have written permission from the parent or eligible student to release any information from a student's education record. However, FERPA allows disclosure of those records without consent to certain designated parties in specified circumstances, such as a health or safety emergency. Remember to check with your organization's legal counsel if the data you work with is or may be subject to FERPA requirements. One federal law that you may already be familiar with, because you sign privacy notices on it when you visit medical professionals, is the Health Insurance Portability and Accountability Act, or HIPAA. The Act provided the first nationally recognized regulations for the use and disclosure of an individual's health information. HIPAA regulates the use and disclosure of an individual's protected health information, or PHI, by covered entities, and holds violators accountable through civil or criminal penalties. Covered entities include medical providers, health insurance plans, and healthcare clearinghouses. Rules under HIPAA are intended to support information sharing by providing assurance to the public that sensitive health data is securely maintained and shared only for appropriate purposes. For example, private health data may be disclosed to public health officials without the individual's consent for the purpose of public health surveillance, investigations, or intervention activities related to disease or infection. Note that not every entity is a covered entity, and simply being in possession of an individual's health information does not necessarily mean that the entity falls subject to HIPAA. The Texas Medical Records Privacy Act, or TMRPA, expands on the HIPAA definition of covered entity to apply to any person who engages in the practice of assembling, collecting, analyzing, using, evaluating, storing, or transmitting protected health information. Except in limited circumstances, the Act prohibits covered entities from using or disclosing PHI without first obtaining an individual's clear and unambiguous consent. The TMRPA also prohibits the re-identification or attempted re-identification of information that has already been de-identified. It prohibits the use or disclosure of PHI in marketing communications, as well as the sale of PHI without the individual's consent. It also specifies how to provide notice to an individual whose protected health information is subject to electronic disclosure. Finally, the Act describes mandatory training requirements for employees of covered entities, and you should consult your organization's legal counsel to find out if this TMRPA training requirement impacts you, or if you have any questions regarding the Texas Medical Records Privacy Act. Organizations that access or maintain criminal justice information may be subject to Federal Criminal Justice Information Services, or CJIS, privacy regulations. Criminal justice information is the term used to refer to certain data necessary for law enforcement agencies to perform their mission and enforce laws, as well as data necessary for civil agencies to perform their mission. The Code of Federal Regulations sets forth the requirement for restrictive access and security practices for data and information systems storing or processing criminal justice information, including biometric data, such as fingerprints, iris scans, and DNA, as well as criminal and/or civil events history information pertaining to the individual, and property data that is accompanied by any personally identifiable information. There are mandatory training requirements for employees who may have access to CJIS data and information systems. So make sure to check with your organization's legal counsel and information security office if you think this training requirement applies to you. You can learn more about CJIS on the Texas Department of Public Safety, Texas CJIS Security Office website. As a data user, you should be aware of other laws and regulations concerning data privacy that may directly or indirectly impact you. For example, the European General Data Protection Regulation, or GDPR, aims to strengthen a European Union residents' control and rights over their personal data. Organizations that collect or process data on European Union residents should consider the GDPR's applicability with their legal counsel. Closer to home, many states in the U.S. have enacted laws to strengthen the protection of citizens' right to privacy. California passed the California Consumer Privacy Act in 2018, which was the first comprehensive privacy law in the United States, granting significant privacy rights and consumer protections for California residents. A number of other states have since passed similar laws, including Texas, which enacted the Texas Data Privacy and Security Act in 2023. While the act exempts state agencies and political subdivisions, it grants Texans multiple rights related to their personal data held by business entities. You can keep up to date on data privacy initiatives in Texas by consulting with your organization's legal counsel. As employees of Texas state agencies and institutions of higher education, we are responsible for protecting the privacy of the people we serve by being good stewards of the data we collect, manage, use, share, and dispose of. We also have a duty to ensure that if an unauthorized disclosure of personal information occurs, the impacted individuals are notified about the breach and efforts are made to mitigate any harm. Chapter 2054 of the Texas Government Code outlines the notification requirements agencies must give to impacted individuals. Additionally, Chapter 202 of the Texas Administrative Code, or TAC 202, describes information security standards such as incident reporting requirements. In the event that unauthorized access to or disclosure of data occurs, any state employee who discovers the incident has a responsibility to report it promptly to their immediate supervisor and to their organization's information security officer or other appropriate office. The organization must also report certain confirmed or suspected security incidents to the Texas Department of Information Resources if the incident meets criteria specified under TAC 202. Note that it may not be possible to gather all relevant information immediately, in which case it is generally advisable to submit an initial report as soon as possible and update the report as new information is collected. Organizations that have inventoried, curated, and classified their data assets are more effective in meeting the reporting requirements outlined in TAC 202, such as assessing the significance of the breach and any potential losses. Consult with your agency's Information Security Office or other appropriate office if you have any questions about these reporting requirements. For more information, guidance on incident reporting can be found on the DIR website. As employees of Texas state agencies and institutions of higher education, we have a responsibility to ensure that personal data collected about citizens remains private. However, governmental entities also have a responsibility to be transparent and accountable to the public for their operations. In the United States, the federal and many state governments have adopted some version of a sunshine law, which is often called a right to information law. These laws provide a way for citizens to obtain information about the workings of their government. In Texas, we have the Texas Public Information Act. As a data and information producer or consumer for a governmental body, you should be familiar with the basic provisions of the Texas Public Information Act, so you can be compliant with all requirements for public accessibility to government data. The Texas Public Information Act articulates that government is the servant and not the master of the people. In the most recent Texas Public Information Act handbook, the Texas Attorney General states that Texans have the right to see how their government is spending their tax dollars and exercising the powers they have granted it. That knowledge is essential to preserving the rule of law, protecting the democratic process, and defending the liberty we all cherish. It is important to keep this central tenet of the Public Information Act in mind as we read, understand, and apply data privacy laws. The Texas Public Information Act requires that all Texas governmental bodies, including state agencies, local governments, and other entities that receive or are supported by public funds, handle public requests for government information uniformly, regardless of who the requester is. These submissions for information are known as public information requests or open records requests. In addition to the requirement to handle requests uniformly, governmental bodies must respond to all requests promptly or within identified statutory deadlines if certain criteria are met. The definition of prompt can vary depending upon the type and amount of information requested, and whether the request calls for raw data or data that is hand-tailored, formatted, and filtered for a specific need. Generally speaking, if an agency or department needs more than 10 business days to fulfill an open records request, the requester must be notified and given a reasonable estimate of when the responsive information will be provided. To ensure promptness, it is important that our record-keeping and data storage systems are set up to efficiently retrieve and extract data subject to this requirement. The goal of right to information laws is to release as much information as possible to the public, and withhold it only when the information falls into a category of exception. Information is or may be accepted from public disclosure if it is considered to be confidential or sensitive by constitution, statute, or judicial decision. A comprehensive list and description of the exceptions to disclosure can be found in the Texas Government Code, Chapter 552, Subchapter C. But some important categories include confidential health records, certain information in personnel files, certain civil and criminal litigation information where the state or a locality is a party in the litigation, student records, statewide network security information, and personally identifiable information, including home addresses and telephone numbers of certain state officials and employees. A governmental organization may not withhold information that it believes to be accepted from disclosure without either consent from the requester or a decision from the Office of the Attorney General that authorizes the organization to withhold the information. If an organization intends to withhold information and does not have consent from the requester to do so, then the organization must submit the information for review by the Attorney General's Open Records Division, which will then issue a decision on whether or not the organization is permitted to withhold the requested information. As mentioned earlier, the goal of right to information laws is to release as much information as possible to the public, withholding it only when the information falls into an accepted category and the Office of the Attorney General determines that it is appropriate for the governmental body to withhold it. Because of the breadth of the Texas Public Information Act, governmental organizations that collect personal information about individuals are limited in the privacy protections they can place on that information. Organizations often cite the Public Information Act, where relevant, in their posted privacy policies to remind constituents that any information shared will be subject to those laws. As employees of Texas state agencies and institutions of higher education, we must continually balance the requirements of protecting an individual's privacy with the responsibility of maintaining transparency and accountability. So it is important to work with your organization's legal counsel if you receive a request for data made under the Public Information Act. By operating within these legal frameworks, governments at all levels can maximize benefits to citizens, residents, and stakeholders, while also protecting their rights. You have now completed the Texas Data Literacy Program course on data privacy. We hope you have found this information useful. During this course, we have discussed privacy principles that governmental organizations should consider as they collect, process, maintain, and disclose personal information, privacy laws and regulations that apply to governmental organizations, and laws related to unauthorized access to data and right to information laws. If you have any questions about the laws and regulations presented in this course, or the privacy impact of the collection, management, use, and sharing of data in your organization, please consult your organization's legal counsel. For more information on data governance and data management principles, visit the Office of the Chief Data Officer website.